Welcome, everyone. Hello. Welcome to our IP and commercialization webinar co-hosted by Spring and our wonderful friends at DLA Piper. So my name is Davina McPhail. I'm the Partnerships Director at Spring and very excited to be part of this webinar with Morgan and Alan. But so before we start, I wanted to acknowledge the lands that we are on. So as a global team residing across the country, we extend this acknowledgement to all Indigenous people who have stewarded and nurtured the land and environment, turning in from the traditional, ancestral, and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh peoples, the original inhabitants of the unceded land known as Vancouver in British Columbia, Canada. So AccelerateIP, what is this? And so AccelerateIP is part of the federal Elevate IP initiative, a nationwide program focused on providing IP support and for early stage companies. So this version of the program, known as AccelerateIP, is specifically designed to support hundreds of innovative startups based in BC, Yukon, Northwest Territories, and Nunavut to grow and protect their ideas and intellectual assets. AccelerateIP is led by New Ventures BC and primate collaborator Innovate BC and provides enhanced access to education, skills development, and amazing financial support for up to $85,000 for protecting, managing, and leveraging your IP. There are lots of partners and collaborators that are part of the program, including Spring, which we are very excited about. If you're connected with Spring in any capacity, we're able to help you access the program by providing referrals, references, general advice, and any further information on the program. So feel free to connect with Natalie from the Spring team. Her email will be shared just in the chat below, and she'll be happy to answer any questions you may have. So other key collaborators in the program also includes registered legal service providers that play a very key role in streams 2 and 3 of AccelerateIP programming. So we're very excited to have IP thought leaders from DLA Piper, a global law firm in over 40 countries, and one of the legal service providers of this program, who can assist you in your IP needs and specific streams. So just to give you a bit of context on this webinar, as you know, IP assets are key foundational building blocks for early stage startups in today's global economy. So understanding how to commercialize them is critical really to a company's long-term sustainability, as it ensures stronger, longer, and wider runways for the company's expansion in the future. So in today's webinar, we'll be discussing all things IP commercialization, including diving into different intellectual property assets, exploring methods to determine the value of registering your IP assets, commercializing your IP portfolio, and finally, leveraging AccelerateIP costs for legal support to propel your IP strategy to the next stage, ensuring that your intellectual assets are at the forefront of innovation and growth. For our speakers today, I'm very excited to be joined by Alan Masek and Morgan MacDonald from DLA Piper in Canada, who are exceptional thought leaders in this space and will be introducing themselves shortly. So DLA Piper has been a great support of Spring over the years, and we're just really thrilled to be doing this together. So just before we start and before they introduce themselves, just a few housekeeping items. So please add your questions in the chat or the Q&A tab on the right at any time. We'll take a moment. Alan will start, and then Morgan will do the second half of the presentation. But so in the middle, we'll take a bit of time to just pause to look at the questions and answer those. So please put them in the chat, and we'll try to get back we'll get to all as many as we can. And if you're a startup, we'll share some important dates for you to look out for and how to stay connected with Spring, DLA Piper, to leverage the most out of AccelerateIP, so at the end. So this is it for me as an intro. And so I'd like to open the floor, I think, to Alan and Morgan, and just so that you can share a little bit more about yourselves.
Awesome. I can jump in there,
Alan,
and
go ahead.
then Alan can continue. Great to see everyone. I see a lot of familiar names on here, and I know this is being recorded, so hopefully if folks weren't able to join, they can join later. My name, as Davina mentioned, is Morgan McDonald. I also see that we have Mike Reed on here. We're both co-chairs of our Emerging Growth Venture Capital Group. So what does that mean? We help startups do kind of anything they'd need. Anywhere from the funding side to figuring out what they're being the initial go-to person on figuring out what on earth IP is, and then we tag in the experts like Alan here, who we're so thrilled to have on the call today. We've been involved with Spring for a while, big fan and big supporter of everything they do, namely bringing info like this and a program like this, which is just really fantastic to all of their community. So reach out anytime. We really do. We don't want to just be talking heads up here. So if you do have questions, we're super happy to get to all of them. The slides will be shared after, I think, or we can. So don't feel like you need to take down all the notes, and we're here to talk. So please, if you do have questions, we want to make this for it.
Great. Well, thanks for having me, and I look forward to the questions and thoughts that others can share as we go through this. As Davina said, my name is Alan Masick, and I'm a partner here at the Toronto office of Daylight Piper. My practice focuses on primarily patents, but our team here does all areas of intellectual property. Most of my practice is focused on helping innovators who have come up with cool ideas, getting patent protection on them, helping them navigate the patent process, figuring out, are patents the right type of protection. And the other part of my practice is doing patent litigation. So when people are trying to enforce their patents or have been received threats of patent infringement, and then taking that through the court system if necessary. So I'm going to jump in as the sort of first presenter here. I'm going to just share some slides here and get into a bit of the background of IP, the different types of IP, and then we can go from there. Just one sec while I get my deck shared. I think that is being shared now. Just in terms of what we hope to cover today, a little bit on types of intellectual property, focusing on patents, trademarks, and confidential information and trade secrets, a bit about IP protection strategy, IP commercialization, and then a bit more about AccelerateIP and how that relates to protecting IP. There's a lot of information on this first slide, but this breaks down some of the key types of intellectual property. We're going to touch on some of these in more detail than others, and the type of IP that may be important to you really varies on terms of company, where the innovation is, where you're going to differentiate yourself from competitors, and it really varies a lot depending on what type of technology is being worked on. The key ones that we're going to focus on here, patents generally relate to protecting ideas, copyright, which relates to works. Typically, if you hear copyright in the context of, protecting movies and songs, but it also protects books, copyright, source code. It covers graphic art, anything like that. Trademarks, names and logos and things like that, which can be used to identify source of products or services. Industrial designs, which are often grouped with patents, but don't necessarily relate to ideas, but to the aesthetic appearance of things that are being sold. And then, often not talked about enough, in my view, confidential information and trade secrets. These are not typically registered. You don't apply for them, but it's the idea of keeping important information as confidential, and can often be a great source of value for companies. This chart breaks down the different types of protection for these, some of the nuances of that. Some of the key ones that I'd just like to touch on briefly are the term of protection. Patents are 20 years from when you file. Copyrights, the life of the author, plus 70 years. Trademarks can be almost indefinite as long as you keep renewing them. And then, for example, trade secrets can also be indefinite if you are able to keep them confidential through either physical means or through contractual means and things like that. There's different ways of obtaining these rights, and we'll get into that a little bit more detail, but I won't. This talk's not intended to get into all the nuances of that. For many of them, you have to apply, in particular the case of patents and trademarks. You're working with either a patent agent or a trademark agent to put together an application, and that gets filed with the respective intellectual property office of whatever country you're trying to obtain that protection. And often, depending, especially for patents, that can be a fair bit of work to go put together that patent application and make sure you get the right protection. Other types of protection, like copyright, for example, often you don't have to register. Copyright arises without any registration steps at all. There can be benefits to registering that, but often people don't register until a dispute or something like that arises. And as I said, trade secrets and confidential information can't be registered, and they're simply kept as confidential through other means. Why care about patents? Often, people hear about patents, but don't necessarily know how they're going to bring value to their business. We'll get a bit more into this later in the presentation, but there's often licensing opportunities, both if you have an idea to license it to others to commercialize in other jurisdictions, or they may have the bandwidth to do manufacturing or distribution or things like that. Patents can also be a barrier to entry. They slow down others from simply copying the idea and moving into your space. Patents can take a while to get granted, and so clients often ask, what's the benefit? What can I do while my patent is still an application before the patent office? You've often heard of patent pending. That is a way of sort of telling the world that there's a patent application out there, and to tread cautiously. Competitors may be less likely to move into that space if they know that there's some patent rights being pursued there, because they don't want to get caught later once the patent grants with potential liability there. And then also patents can be used defensively. If someone else comes at you with their own patents, you can potentially reach negotiations because they may be infringing on your patents, and as a way to resolve those kind of disputes. And also, often an important part of patents is the recognition of the innovation that's being done, sort of a concrete way of saying, look, we think we have some clever ideas here. We've taken steps to protect those ideas, and often that can be quite valuable for investors or others who are looking at a company. I touched on this earlier. Patents are a term of protection for 20 years from the filing date. And so after 20 years, they've expired and anyone can use that idea. And the sort of idea behind patents is that by putting the ideas into these patents, you put them into a database, others can refer to them, and you get a term of protection of 20 years in return for sharing the idea. So the society benefits because these ideas get shared, and what you get in return for sharing the idea is this term of protection. The patent doesn't actually give you the right to sell or move into a market. All it does is allow you to prevent others from practicing the idea. And this comes up because most patents are improvements on existing technology. And so, if there's an existing product out there, it may have a patent. And if you come up with an improvement on that, you may still need the permission of the original patentee in order to sell that improvement. They can't use that improvement without getting permission from you, but it could be a situation where you can't actually sell that product without talking to the original patentee. In terms of infringement, which is where a lot of my work comes in terms of dealing with patent infringement allegations, patents can be innocently infringed. There's no need to have actually copied the idea from someone else. If two people independently come up with a clever idea and one of them gets the patent, the second person who's had no idea the patent existed or even that the idea had already been developed can still be liable for patent infringement. And so we'll get into this a bit more. There is sometimes benefits doing freedom to operate searches, which is to go to check to see what patents may exist out there that you're not familiar with. I'm not going to get too much detail on the cost of patents. There's lots of variations in terms of patent strategy about which countries you pursue patent protection, how many do you file, those sorts of things. And there's a lot of steps that can be taken to speed up the process, try to get a patent sooner if there's a desire to try to assert the patent against somebody. And often there is a lot of benefits to slowing down the process to defer some of the costs of the process to later, after funding rounds and things like that, or after there's been some commercialization steps taken to really understand how big the market is. And so there's often a lot of thought goes into deferring some of the key steps of patent protection and defer those costs. It is important to think about patent protection. One of the key decision points is that for many jurisdictions, if the idea has already been shared publicly, then it may not be possible to get patent protection that has value. Europe, for example, has absolute disclosure requirements, which means that if the idea has been shared on a website already, and then 3 months later you file a patent application, it could be that European patent can be found invalid because of that earlier disclosure. Canada and the US have a grace period for 12 months after your own disclosure, but as I said, most countries do not. And so it's really important that if you're thinking about patent protection, that you talk to a patent agent and think about your strategy before you go to that trade show, or do show it, put all the details up on your website and those sorts of things. And as my last point mentions, there's also the concern that someone else could independently come up with the idea before you file your patent application. As they say, the patent system is a race to the patent office. So it doesn't matter who came up with the idea first in their head. It really comes down to who filed the patent application with the patent office first. I see a couple of comments about patents that have come through. There's a question here about accidental patent infringement or innocent patent infringement. I would say that that comes off my comment about in coming up with the idea independently. I would say that quite often that is the case. Most people are not out looking at patents every day, and so they are simply developing their product, talking to their engineers, and coming up with new products. And they may have commercialized the product, be out there selling, and then suddenly a company they've never heard of comes along with says we have a patent on that or a certain feature of that product and sues them for patent infringement. And so I think that happens quite often. Most of my practice is in the non-pharmaceutical space. I think it's a lot different in the pharmaceutical space where there's brands and generics, and people are creating generic versions of drugs, which is where a lot of litigation takes place. But outside of that space, I think it's a lot more common to have this innocent patent infringement scenario. I'd like to move on to trademarks. Just in the interest of time, I'll try to get back to some of the other questions on this a little bit later. Trademarks are about brands and building goodwill in the marketplace around your products or services. Almost everybody is going to have a logo or a name that's associated with their product or service, and there's important benefits to trying to get that registered. Some of the key ones in terms of enforcement is that having a registered trademark can be very helpful in the online world in particular, against cyber squatters, Amazon Marketplace enforcement things, and taking out knockoffs and things like that. If that's sort of at all where your business is going, definitely take a look at getting trademark registrations, because that's very helpful there. It's also can be very helpful in terms of maintaining control of your products or services if you're working with distributors and resellers. Trademarks are, a sort of a way that the end consumer is dealing with your product or service and knows where it's coming from and who's sort of behind it. For trademarks, there's a couple of types of protection on this. There's a trademark legislation that allows people to enforce their trademarks against others. That can be things like straight knockoff, they just using the same trademark or on their packaging in order to confuse people into what they're buying. And it can also be in scenarios where there's depreciation of the goodwill, where people are sort of slagging the brand, and there's a certain way of enforcing in the marketplace to protect that trademark. In terms of the confusion, there's I set out some of the factors there in terms of the confusion. Often this comes up when there's similar marks, either accidentally or on purpose, where people have come up with a mark that's very similar to an established brand in order to try to grab some of that goodwill in the marketplace. Sometimes it's sort of innocent. A brand develops in Vancouver, and somebody else independently is coming up with a similar brand in Toronto, and that's all very well and good if they're marketing locally, but then as soon as they start marketing online, they realize that there's confusion because they're both using the same trademark. That comes up, unfortunately, surprisingly often, and it's sort of very difficult to unwind, because at that stage, both companies will have invested perhaps years of marketing and are now sort of at loggerheads in terms of who owns the online presence when they've both been quite active locally. I just want to touch on non-disclosure agreements. This often comes up in the patent space if you're talking to others before you've filed your patent application, but it also comes up when there's trade secrets involved. If you're working with others on manufacturing process or a new type of material, or even on sort of the software side in terms of algorithms, and access to sort of that the secret sauce behind an online offering. So NDAs, non-disclosure agreements, can be a very important part of dealing with others on that. That can cover basically anyone in terms of contractors, but also suppliers or distributors, depending on what access they have to the sort of the technology or the confidential material. Public disclosure can be important, as I said, for patent protection if there has been a public disclosure prior to the filing of a patent. If there's been disclosures under a non-disclosure agreement, those would typically not be a public disclosure for patent in terms of potentially invalidating a patent. So that's why it's so important there. The last point here is about non-disclosures in the fundraising world, talking to investors. Morgan, I don't know if you want to touch on that a bit more.
Yeah, no, absolutely.
With the role of NDAs there, and I know it's a tricky area, and really depends on the context.
I think the point here is just that a document can have a name and not necessarily be the same thing. So, a lot of people will look at something and say, hey, do you have an NDA? Sure. There's lots of different types of them. It really matters what is in that NDA and what it restricts people from doing. And a non-disclosure agreement could be so broad as to prevent somebody from, investing in a later company if it's somewhat related to the early stage of information that they had. And so there is some automatic there's a few things to be aware of. One, although a document has a nice title, you got to read the actual document in there and in how it relates to your situation, how you plan on using the information, or not sharing, or not using the information, and how you share it, and really, really think about the scope in which you're using it and the purpose for which you're using it. Not all documents are work for one situation, even for the same parties, as they would work for another. And there's a lot of different ways. I mean, even in like a one-page NDA, there's a lot of different ways that you can shift things up. And so just being thoughtful about what the document says, does it actually work for your purposes, rather than just signing an NDA? And then the other point kind of is around the time that you use it. Non-disclosure agreements don't really do much if the cat's out of the bag. You can go and sue somebody for, the damages you may or may not have, but if that, if there has been a public disclosure, then, you're kind of a little bit SOL. So, so think about when you're using agreements, and when you're sharing the actual information that truly is really important and really proprietary to your business. Do you need to have, your mom sign an NDA before she invests $5,000 in your company? No. And like, do you need to have somebody sign an NDA before you share your first pitch deck? No, ideally you're not sharing all of your kind of secret sauce or whatever your code is, or anything like that in your pitch deck. But once it, there is a certain point at which it does get valuable, or we're kind of required, if you're going towards something like a patent filing, or intending on keeping your trade secrets actually confidential, to get into that type of territory. So all to say that the title of a document doesn't mean much, and you actually have to think about when it's used and how it's used.
Great points. I think another part where these kind of where agreements can become really important are with collaborations. Those are come up in all shapes and sizes for everyone, and they're all very different. Sometimes that's simply working with a consultant that is not an employee, but they're working on one aspect of the project. That comes out with joint ventures, whether that's for co-development purposes, or simply for manufacturing, or you're working with somebody else who may be a more established player in terms of distribution, or they're going to be marketing the product or service. In all these cases, it's really important to look at the IP issues. Some of the ones that I've seen and come across, which are really hard to unwind, are where they haven't dealt with sort of co-development. What if there's improvements to the original idea that were originally yours, but there's been improvements that have been developed by the other party to the collaboration or the joint venture. Who owns it then? What happens when the arrangement comes to an end? Who owns the IP, or does the other party have a license to continue using that IP for whatever products they may have? What happens with that co-developed improvements? Do both parties own that, or just one, or just the other? Those can be very hard to predict in advance, but they're much harder to unwind after the fact, when perhaps the relationship has deteriorated. And the other part I would really also mention is that the default rules for who owns this co-developed or originally developed IP is not necessarily intuitive, and can be very difficult to determine after the fact. Patents, the rights flow from the inventors. Who are they employed by? So that the consulting company may own IP if the consultant comes up with an idea, and it's not been addressed in terms of the joint venture agreement or the consulting agreement. Copyright is going to be held by the authors, and the ownership of that may also have not flow through to the person who's paying the bills at the end of the day, if that has not been addressed properly in the agreements. Joint ownership of intellectual property is an area that seems attractive, but can often be fraught with problems later on. I typically try to avoid scenarios where that comes up. and often recommend sort of licensing arrangements instead. But it comes up, and it's, as I said, it's harder to unwind once it's already been in place. Just touch on a couple of areas where IP comes up early in this process. Think about what IP is actually being developed by your company. Is it software? Is it simply an idea of a new manufacturing process or an idea for a product? What that IP is can really change what your strategy is and what needs to be protected and where the value needs to be documented and for further purposes. Look at the what I call IP landscape. What are the competitors doing? What kind of IP do they have? Do they have patents on related technology? Maybe that might indicate that pursuing your own patent protection makes sense. If no one has patents in the space, why is that? Is there something about the type of IP that's being developed that's not suitable for patents? Maybe that means that there is an opportunity for patents there, but it's something to look at. And I think it's also on the branding side, with trademarks. Do people have lots of trademarks in the space? Are they trademarking every variation of the product? Is it just the parent brand that's being trademarked? Look at all those to sort of see what others are doing in the space. Touched on some of the contracts that involve IP. Obviously employment agreements, but also with the contractors and suppliers to make sure that IP is being properly handled there. We touched on freedom to operate. That comes up in the patent space. What do the competitors already have patents on key parts of the product or service that's being developed? It also comes up in trademarks. Before you spend lots of money on a new brand, maybe do a check to see if someone else is already using that brand or that trademark in the space to make sure that you're not going to get in trouble there, especially after you've invested a bunch of time and energy pursuing that. Patentability analysis, it can be important if you've come up with a new idea to see, is it something that's really patentable? Is it new? Is it inventive over the existing technology? And then, is it something that sort of suitable for protection, especially in the software space? There's a fair bit of controversy about what's patentable in terms of software. Patenting business methods, and often very difficult to get patents on software. And so maybe it's better to pursue that by way of a trade secret, depending on the nature of your product or service. Often sort of cloud-based software products where the sort of secret sauce can be kept on the server side and the customers don't need to know how it all works, are quite often suitable for trade secrets. If the product or service is being basically given to the customers as part of the transaction, then patents may be more attractive because it's easier to be reverse engineered, and there's sort of there's no secret in how it's being made or sold once it's out there. To touch on the clearance searches, which is under trademarks, similar to the freedom to operate for patents, and then consideration of the timing and stages. There's often lots to do with the IP, but looking at what's being done right now in terms of the product and services that are being launched, and where's the real value? It's important to get to market right away, and that's where the value is going to be, or is it going to be sort of a longer game where patents may be more valuable to sort of fend off the competitors? So that's sort of the overview on the sort of IP side. And before I turn it over to Morgan, I just want to pause for questions that have come in. I see one question here about provisional filings for patents. I can just touch briefly on that. A provisional patent is something that's unique to the US patent system, but can be very valuable for anyone, including Canadian companies, as part of their patent strategy. Filing provisionally can often be very beneficial because the cost can be quite a bit lower than filing a formal or non-provisional patent application. And it basically buys you a year before you make decisions on filing a formal application. And so that can be very helpful if money is tight, because you can hopefully have more money a year from now in terms of formalizing that application. And it can also be very valuable if the product is still being developed. If you are going to a trade show soon, get your provisional patent application filed, especially if you know that there's going to be a year of further development. And a year from now, when that time comes up to do a formal application, your product is going to be closer to commercialization. There's going to be some new features that are still being worked on and fleshed out. And so, it makes sense to file a provisional so you're not sort of locked in with a formal application initially. Maybe I'll turn it over to you, Morgan, to talk a bit about commercializing IP.
For sure. Yeah, so once you have the IP, what's next? There's lots of different ways that you can, you can effectively make money on your IP. And I'll touch on these very generally, but really everybody's scenario is going to be quite different. So I don't want to go too deep into limiting the ways that you could be thinking about it, because I'm also not touching on kind of a joint venture, et cetera. But generally, you're either going to use it, which means you are manufacturing something, you are selling, you created your own trademark and you're selling, a box or a product with that trademark and brand on it. And you're actually using your own IP as your good or service that you're selling. That would bring you continuous revenue. That's kind of your whole business model. You could, in addition, or alternatively, be licensing your IP for other people to use it. That could be, thinking about a software license or basically any other right to use the IP, a trademark license, or anything like that. I'm going to focus on licensing really in considerations there for this talk, but the next is to assign the IP, and really that falls into divesting or selling the IP. So you wouldn't be using it anymore, you're just selling it. It's a one-time payment. And yeah, that's fairly obvious. In terms of licensing your IP, what a license means is that it's really just a right to use it. And I'll use the example of a car or an item that is very specific in terms of discussing how a license, all the things you'd want to consider for a license, because sometimes the idea of licensing IP can be a little bit amorphous in what the actual IP is. And as I kind of mentioned with my sort of blurb on NDAs, agreements aren't all the same. They're all different. They all say different things. The devil's in the details, and it's what we actually read all the time. I know they can look very, very similar, but they're certainly not. And the purpose of commercial agreements are to, one, get the expectations and assumptions out of the way in the first instance, but they're also very evergreen documents. So you need to be, if there's a dispute or a default, you're going back to those agreements and figuring out how the parties are going to behave. So it is very important that you have, that you really do understand how your documents work. Get something into place that isn't necessarily just, first get something into place. And then really understand what it is. But if I explain IP in terms of, like, imagine your IP is a car. Since a license is really just the right to use something, there's a lot of considerations once you get a little bit past that. So, say I give Alan the right to use my car. I give him a license to use my car. When can he use it? Can he use it when I'm going to use it? Can he use it, between the hours of 8 and 5, or do I need it at that point? Am I able to use it as well, or is only he able to use it? That would be the concept of sole and exclusive versus just exclusive or just a non-exclusive license. Who pays for the license? Is he paying for the ability to use my car, or is he able to sub-license that right and give other people the right to use my car? And who are they going to pay him, and then I'm going to receive funds back from him, or how is that going to work? what happens if the car breaks down? What happens if something needs to be fixed in whatever the IP is that we're licensing? Do I have to give the car back? Do I have to give them credits to use the car again? Do I have to fix it and repair it? And is that it? Lots of considerations there, but ultimately they come down to the who, what, where, when, how, and why can you use this piece of IP. And so when you're getting into licensing your IP, you're really going to want to be carefully considering a lot of these aspects, and I'm going to touch on them just for 5 minutes because I know there's a lot of questions here, and I think that's probably the most valuable portion of the talk. The kind of high level items that I discussed are sole and exclusive versus sole versus non-exclusive. So can I just use the car? Can myself and Alan use the car, or can I lend out anyone in this talk the ability to use the car? And what does that mean for each other party's rights? In terms of territory, where can they use it? Can he drive it anywhere? Can he just drive down the street? Is this going, and really thinking about how that's going to, and the car is not a great example for that one, but can I use this trademark just locally, and then I'm going to be licensing that trademark out to use in Europe, and somebody else is going to get to brand the brand of product in Europe, and I'm not going to. I'm just going to step aside from that location and that territory. In terms of the term, how long can they use it? Can they use it forever? In terms of something that you're building into your own product, like software that you're building into and relying on for your own product, you're going to probably want that to be perpetual if it's because you're always going to need it and you've now relied on it. It could also be term limited, so you can only use this piece of IP for a certain period of time, then we need to come back to the table and negotiate. Is it irrevocable or revocable? Kind of similar in terms of perpetual and time limited. Can I just pull that license if you are, for any reason, or if you're not complying with the agreement, or are we really just negotiating everything right now? It's irrevocable. I can't take it back. Here we go. Or is it, contrary, or sorry, not contrary, would be, is the license transferable? Can I sell the license? Can I, or sell the right to use it? Can I transfer my license to somebody else? Can Alan give the right to use the car to Davina? Do I have a say in that or not? And when you're thinking about that, consider whether or not you're selling the company if that is taken into account for transferability, because oftentimes the IP will be a lot of the value of the portfolio of whatever somebody's expecting. And then how are you going to get paid? Are you going to be getting paid on just a fee structure? Are you going to be getting paid on a royalty or a revenue fee structure? And how is that going to work? And what happens if it is a royalty? Am I going to be able to go back and see how much you actually sold of that product, if that's what the revenue is based off of? Can I audit you? Is this, how is this calculated in terms of tax and monetizing the actual IP? And then in terms of improvements and modifications, Alan mentioned, IP it can typically be bettered. It can typically, there can be new features. Who's going to own that? If I've given Alan the right to use my car and he thinks, oh, I made, I don't know, a bigger spoiler and it works better. So now he just owns that piece of the car, or what happens? Is that mine now? Do I own that because it's on my car? Those types of things need to be worked through, ideally in advance, or at least a policy to determine, or a procedure to determine how those things will be determined in the future. And then acceptable use and prohibited use, and in reserving any rights. Really setting out the ways in which you cannot use somebody's IP what we're reserving for what I'm reserving for myself, and any ways that any things you can't do, like with respect to a patent, you can't reverse engineer it. You have the right to use it, but you can't reverse engineer it to figure out what it is on your own. And then at the end of the day, you're really going to need to figure out a way to enforce and defend the rights of that you're licensing out. So the agreements would really set out, or the licenses would really set out how that process goes. You know, is it as a notice? Are you going to be meeting together to figure out a breach? Are you going to be expecting that an indemnity for a breach? Are you going to be expecting confirmations that anything that I've done with respect to my car doesn't breach somebody else's third-party rights? All very quite complicated. But all things that really are the additional questions that come up once you get past that first, okay, I have a car and somebody can use it. There's really, really a lot more to dig into once you get past that first section of, you know, here we go, here's my IP, now what? I had also set out in the slides what is AccelerateIP and kind of how do you use it. I'm not going to go too into depth here because my high level is, this is an amazing program. When I learned of this program, I was shocked. There are funds set aside for you to actually create an IP, learn about IP. That's not the funding part, but amazing programs like Spring are bringing this to you, so you can learn about IP, and then you can work with folks and have the government pay to strategize your IP and then actually commercialize it. And quite frankly, it's quite broad, and it covers a lot of items. It does require some thoughtfulness in advance, and folks who are you know, properly approved through the program. But this is a huge benefit that I think that I kind of want to shout from the rooftops when people think IP is really expensive, because it is. It absolutely is. But this is a great program that people should be taking advantage of if they're able to. We'll drop it to questions now, and Davina, I think you're going to pop back in.
Yeah, no, thanks, Morgan. And yeah, like echoing also what you just shared on this AccelerateIP, you know, really a great resource, you know, for anyone who needs all the practical applications that you guys just described, which are, you know, complex and require, you know, someone who knows to support. So I just wanted to go and look at the questions here. We had quite a few good questions. If that's okay. I
do need to correct one point on my slide. I said that SHRED is the Innovation, Science, and Economic Development. It's actually a program run by the CRA, which I did not know, but that makes sense.
Here you go. Also
a great program.
Yeah, yeah. No, but so like I wanted to share Christine's question. It's her first question. So I don't know if it's might be it was when Alan was talking, but feel free to answer. Can you talk a bit more about patents on software and algorithms, the obvious disadvantages plus potential advantages of situation where it could be beneficial over keeping trade secrets?
Yeah, it's a really good question, and there's no easy answers there, unfortunately. I sort of touched on this, that often it depends on the product or service that's being offered. You know, is it something that the end user can reverse engineer because it's readily apparent to them, either because they have access to the source code or can figure out how it works from the tools that they have access to, which is an indication that maybe patent protection might be more suitable. And if it's something that's completely server side and sort of a black box magic, then it's something that's much more suitable for trade secrets. And my classic example of that is, you know, the Google search algorithm, where, you know, we all use it every single day. You know, we know what the inputs are, we know what the outputs are, but in between, there's obviously lots of magic that goes on, and big chunks of that are trade secrets. And so that's something that, you know, people use all the time, and it's public facing, but they've kept a whole bunch of it as trade secret rather than patent protection. And for patents in software space, it can be difficult to get patents there. The the patent offices sort of go back and forth on this, but don't like giving patents for what they call abstract ideas, simply something that you can do in your head, but you're now doing it on a computer, sort of just straight up algorithms. And the other problem with patents is that you have to put all that detail into your patent application. And then, 3 or 4 years later, the patent office could say, sorry, we're not going to grant you that patent. You can argue with the patent office for a few years longer, but in the meantime, all your competitors can see your algorithms there in the patent applications, because those all get published a year and a half after you file them. So it is a tough trade-off, and there's no easy answers in terms of one as a benefit to the other. It really depends on the specific scenario in terms of which one's the best for a particular company.
Great, thanks. There's also another question from Greg regarding, does a product formula using inputs available in the open market have the potential to meet the bar of a novel, non-obvious solution to those experienced in the art? I hope I shared that question correctly.
Yeah, I'll jump in on that one. Again, the answer is a good, nice lawyer answer of it depends. Doing an assessment of something, whether a particular process is obvious or not, is sort of what I do every day. And we have whole litigation cases over whether something's obvious or not. Almost all innovation is based on existing technology. And so, no one is coming up with something from, brand new that's never existed. It's always going to be based on existing tools, existing materials that are already out there, and it's an improvement on those. And so it really depends on, if other people use these inputs before, have they taken a different direction than you're going, because you come up with a new idea of doing that. If the application of this existing technology is simply slightly bigger, slightly smaller, slightly faster, that's probably not as applicable to patent protection. But if it's being done in a new way that comes up with sort of a surprising result, those are sort of indications that something is going to be inventive and more suitable for patent protection. But it really depends on the specifics and what the technology is and what's been done before in that particular space.
Yeah, so get in touch and then we can share more. And the last question also from Christine. So this might be really in the weeds, but I'm curious about licensing data sets specifically. If you have amassed valuable data from our users and want to monetize it through licensing agreement, how do we ensure that it's actually protected and not misused? Great question.
That's probably false to me. Yeah, first, ensuring the proper scope of your license. So ensuring that you have an understanding of what the scope of the data set is, exactly how it can be used, how you're able to kind of police it, and really what happens on a default, or if you determine that it is being misused. Are you able to pull it? Is that revocable? And are you really able to kind of control that? I would also say if there's a data set containing other folks' information, that I'm kind of seeing it in terms of you've amassed valuable data. It could be other people's personal information or information that you actually would need the ability and approval to share that and monetize it with another party. So just flagging that additional conversation. Or consideration. So unfortunately, it's not exactly how can you ensure it? How can you ensure it's not being misused? Rather than, it's not a better answer than you need to really get into a discussion in terms of licensing with the party who you plan on licensing with, to get an understanding of exactly how they plan on using it, what the scopes are, or what the limitations are around that scope of use, and what your ability is to pull that data set and anything that was built from it, to the extent that you find out that there has been a breach of the license.
Yeah. Thanks for that. And I see, just looking at the Q&A, a few questions there. Maybe also a question for you, Morgan. Could you talk more about how to calculate IP value in case of licensing IP?
Okay, so in terms of, there's a few. Well, I mean, it really depends on what the thing is, right? Is it and how the fee is going to come about. Is it a licensing a trademark, and it's a percentage of the value in terms of the sales that are made? That's typically just a negotiated point. If are you trying to value the IP for a fundraising or something like that? Also a little bit nebulous, honestly. If it's a patent, it's a little bit easier to probably tell. There is some level of, I mean, maybe Alan would disagree with me, but you have sales coming from that product that only can be attributed to whatever the piece of the protected IP that you're using. So there's a lot of firms that go in and try to determine a value of your IP specifically, but oftentimes it's just a commercial point in terms of the value that you ascribe to the use that you're providing.
I completely agree with that. And for patents where sort of, well, I have a bit more experience on, it really depends on the circumstance. Some license agreements are considered sort of bare patent license agreements, where it's basically, I have a patent, I'm licensing you the right to use it, and you are responsible for manufacturing the product, creating the supply chains, doing all the marketing, selling the product. In which case, the royalty rates are going to be relatively small. If I already have a product that's known in the marketplace and I'm just simply licensing you to, use it in Europe, and I'm going to be selling you the product that you are then going to sell in Europe, then it's obviously going to be a much higher royalty rate because I've done way more work and way more investment into that product. And so, it's going to be everywhere in between. Whether it's just distributed by my market, I have the Canadian market, I'm licensed in the U.S. market or something like that. But it really depends on how much am I giving you, and how much are you supplying to the relationship, in terms of.
And how much am I continuously doing? Like, am I continuously providing you updates? Am I continuously providing more literature for your end users? Am I fixing the any issues that come up for you, or is it really just that super early stage? So unfortunately, everyone's getting a lot of answers of like, it depends, because that's kind of the problem with a broader talk on a broad topic. But we're always happy to chat with anybody. And honestly, one of the questions in here is, how can DLA Spring assist with AccelerateIP? I'll let Davina speak to the Spring side of it, but this is like, and the AccelerateIP link was in here as well, but they set out all of the types of, there's the 3 streams, and then there's all of the types of fees that can be, or work that can be applied to the fees. And really, it covers a lot of these discussions. Actually, contract drafting, like the whole drafting of all of the right to use and everything I was discussing there, that covers those fees up to $60,000. So it's yeah, I think look into the program, apply, and a lot of this coverage could be made up, which is really awesome.
No, great. Thanks. And, on the Spring side, if you're connecting with Spring in any capacity, we're able to provide you referrals on kind of both the learning and the trainings, but also like how to access this pool of funding and then these great resources. So thank you. I'm going to wrap it up here. I'll share a few dates, but just wanted to thank you both, Morgan and Alan. I think, Alan, thank you for sharing also that that slide on collaboration, how to think of IIP in kind of collaboration context. I think this is really super valuable, especially for founders who are, in the fundraising process or looking to raise. I think those are all like super important points. So thanks for sharing that. And Morgan, now I will not think of my car in the same way. I'll like really think of IP next time. No, but I thought it was really good to have like that concrete example just to help us visualize a little bit like all the implications here. So thanks for that. yeah, so just to a few dates and touch points for any of you here who are interested in engaging with all of this. Of course, stay in touch with and stay connected with the team at DLA Piper. We shared some contacts there, but some important dates. So applications for streams 2.2 and 3, where we'll be able to access that 85K of cost for legal support. So that reopens on April 30th, so quite soon. So keep an eye on that, and then please make sure you make sure you use these opportunities and get in touch with Natalie at Spring. Her email is shared again, so that you can ask any questions, see how that fits for you, where you're at, and what will be the upcoming resources that you can access. So thank you all for joining us today. Have a great rest of your day. Speak to you soon. Thanks, Morgan.
Thanks so much, everyone.
Thank you.
Thanks.